bring it back to her.
So you mentioned the dissents. There were 4, Jean, that actually wrote and spoke on religious liberty. First, what do you think about the extent of the dissents being 4 of them, and specifically on the religious liberty topic, how much weight is to be given to those arguments compared to what Justice Kennedy had to say about it?
Well, I think what's interesting to me about the decision, including both the majority and the dissent, is the extent of the recognition that there really is a conflict between same-sex marriage or institutionalized same-sex marriage and religious liberty. And you might wonder, why is that? And what a lot of people don't seem to recognize or remember is that all 3 of the major Abrahamic religions, Judaism, Christianity, and Islam, and indeed all other major world religions have for millennia, to use Justice Kennedy's word, for millennia they have taught that a man-woman union is not just an incidental feature of marriage, but it's central to marriage. And that, of course, is fundamentally different from some religious teachings about interracial marriage, which, of course, was the issue in the Loving versus Virginia case. I spent my high school years in the South, and I never heard of any religion that viewed racial homogeneity as a central defining feature of marriage. There were some people who thought that that was preferable for sometimes religious reasons, but I'm not aware that any small or large religious body has ever taught that racial homogeneity is a central defining feature of marriage. And so that's fundamentally different from the situation that we have with respect to same-sex marriage. And yeah, there are a few religious groups that have broken from that tradition, but if you look at the number of people that claim to adhere to those religions, it's a pretty minuscule percentage of the population of all believers. And so there is this enormous conflict, or at least enormous potential for conflict between same-sex marriage in general and the decision in Obergefell specifically, and religious freedom. And that may well be one reason that Justice Kennedy sort of went out of his way in numerous places in his opinion to try to suggest respect for the religious viewpoint on this issue. And in fact, I think of all the opinions that have been written in the course of this litigation over the last couple of years that have ruled in favor of same-sex marriage, Justice Kennedy's opinion is probably the most respectful of religion. And so those of us who care about religious liberty can be grateful for that. And just for example, Justice Kennedy did not rule that traditional marriage laws were based on animus or hostility or bigotry towards gays and lesbians, and there were a number of people who were urging the court to rule that way. He did not rule that traditional marriage laws are irrational, as Judge Posner, who used to be considered a conservative judge, ruled for the Seventh Circuit not long ago. Either of those rulings would have been taken as a holding that opposition to same-sex marriage is in effect a manifestation of religious or other bigotry against gays and lesbians, rather than being an intellectually defensible position. Justice Kennedy also implicitly rejected the U.S. Justice Department's position that sexual orientation is a suspect class and therefore entitled to special rights in constitutional litigation. And that kind of a ruling would have created a whole host of religious liberty problems outside of the marriage context. So, those of us who care about religious liberty can be grateful that Justice Kennedy's opinion dodged some big bullets. But the opinion unintentionally, I think, launched a number of grenades that are still in the air. And as I've thought about it, I've identified really 12 concrete threats to religious liberty, what I call the dirty dozen. And in the very short time that we have, I'm not going to try to explain them in detail, but let me at least list them, and then maybe we can talk about them later. One, of course, is the issue that was raised by Justice Alito at the oral argument, about tax-exempt status. And you probably remember that exchange between Justice Alito and the Solicitor General, Don Barilli. Justice Alito asked him, well, if we rule in favor of same-sex marriage, doesn't that create a risk that religious organizations that believe in the traditional view of marriage would have their tax exemptions revoked? And Mr. Barilli, after initially appearing like he was going to try to dismiss the question, decided that he needed to be frank and honest, and he said, I can't deny, Justice Alito, that's going to be an issue. Yes, it's going to be an issue. And so that's certainly and it is going to be an issue, I suspect. And the fact that the Obama administration has not done anything to walk back from what Mr. Verrilli said at the oral argument suggests to me that there may well be people within the Obama administration who are actually planning to issue a regulation or some kind of a decision that would in fact deny tax exemptions to at least some religious institutions that choose to adhere to the traditional understanding of marriage. And my first 6 examples are in the area of what I call institutional religious freedom or religious liberty. That is the ability of religious institutions to carry out their self-defined religious missions. The other 6 are in the category of individual religious freedom. So the second one is an issue that Justice Scalia raised at oral argument, which is a church's authority to have marriages performed by its pastors recognized by the state, recognized by civil government. And of course, that's the standard practice now. Any minister who marries people in the United States, that marriage is recognized not only for religious purposes, but for legal purposes as well. And Justice Scalia raised the question, well, if we rule that same-sex marriage is required by the Constitution, isn't that going to set up a situation where churches that don't believe that a same-sex marriage can be religiously legitimate, aren't they going to be denied the ability to marry people and have those marriages recognized by the state? Aren't they going to be denied the ability to marry anybody and have those marriages recognized by the state? That, I think, is likely to be a serious issue over time. Chief Justice Roberts, during the oral argument and then in his dissent, raised the issue of religious school housing policies. As you probably know, most religious colleges in the country have policies that they have special housing for married students, but in order to use that married student housing, you have to be married in accordance with the beliefs of that particular religious college. And the Chief Justice raised the question, well, aren't those kinds of policies going to be at least cast into doubt if we rule in favor of same-sex marriage? And that's another serious issue. An even scarier prospect from my standpoint is the licensing area, which of course is very important in higher education. Religious colleges, like every other college, they depend on their ability to get accredited by a wide variety of accreditors in order for their students to be able to get federal funding, and in order for their students to be able to get jobs in a lot of professions. And so if same-sex marriage is really the law of the land, if it's really constitutionally required, isn't there a risk that accrediting bodies are going to start pressuring religious colleges to recognize same-sex marriages for all purposes on their campuses as a condition of accreditation? We've seen a similar issue with regard to other religious organizations like Catholic Charities that in some circumstances need licenses to carry on their works. For example, licenses to place children for adoption and those sorts of things. And Catholic Charities has already been forced to withdraw from providing adoption services in some states as a result of licensing policies that told them, in order to be licensed in our state to provide adoption services, you've got to be willing to place children with same-sex couples on equal terms with opposite-sex couples. And of course, to do that would have violated the religious beliefs of Catholic Charities, and so they chose to withdraw. That's going to become now a nationwide problem. not just a state-by-state problem. And then more generally, religious institutions constantly face the question of can we apply religious criteria in making employment decisions, in deciding whom to hire and whom to promote and all of that. And of course, for churches and religious colleges and other religious institutions that adhere to the traditional definition of marriage, obviously they want to be able to hire people who agree with them about core issues like marriage and the purpose of sexuality and all of those sorts of things. But the Obergefell decision casts into doubt their ability to do that, at least in some circumstances, probably not with respect to federal employment laws, because there's a pretty good religious exemption in federal law, but there are a lot of state employment laws that don't have similar religious exemptions, and so religious organizations in those states are gonna face a serious issue of to what extent then can they continue to apply religious criteria.